Violation of protective order. What is a protective order? How do you modify a protective order? And what are the ways to avoid being charged with the Texas crime of violation of protective order? Hi, I'm Jeff Hampton with the Fulgham Law Firm. I want to thank you for joining us here today. Today, I want to talk about all things related to protective orders and domestic violence cases and what is the crime of a violation of a protective order. And by the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. All right, let's jump right into this. Now, first of all, here's what happens. In Texas, it's very important if you are charged with the crime of violation of protective order, you need to make sure you've hired a very experienced and aggressive criminal defense attorney, because if you are convicted of the crime of violation of protective order, it could result in the loss of certain gun rights. It could remain on your record for the remainder of your life. There are many, just in addition to jail and fines and all the other things that can go along with it. So you need to make sure you get to the bottom of this and understand what the law requires the state of Texas to prove beyond a reasonable doubt. Now, the most common context that someone has a protective order placed upon them is in a domestic violence allegation. However, here's the thing, it's not just domestic violence. Particularly in Texas, you can have a protective order placed upon you for many other types of crimes. For instance, sexual assault, stalking, indecent assault, trafficking, and other household dating or family violence-based offenses many times will carry with them a protective order that's placed upon you, all right? Now, let's identify first, before we talk about the crime, let's talk about what it is. What is an emergency protective order? If you have been arrested for a domestic violence crime as part of your arraignment, here's what's going to happen. A magistrate judge will come in and issue an emergency protective order by operation of law. Why? Because there is an alleged victim of domestic abuse. Okay? This happens automatically. Now, it can happen because an alleged victim requests it, or it can happen because a judge mandates it, or if there's specific family violence allegations involved, the law can require it as well, okay? Now, here's the thing. That time frame can run anywhere from a minimum of 30 days up to 90 days for that protective order. Now, what does that mean? People call and ask us all the time, if I have an emergency protective order placed on me, does that mean I can't contact them? Well, usually what it means is you're not allowed to contact the alleged victim. You're not allowed to go within 500 feet of the residence for which is listed on that protective order. And it really depends. Sometimes protective orders will allow contact as long as it's not harmful or injurious. But other times it can completely prohibit any contact whatsoever. So it's critical that you talk to an attorney about exactly what the rules are about your specific protective order. Now, here's a question I get all the time. Well, I can't contact them, but what about them contacting me? I have that person calling me like crazy. I have that person asking me to go over to their house. I mean, look, I'm not doing anything wrong if they're asking me to go, right? Wrong. Here's the thing. This is one of the biggest problems that we run into. Many people will pick up a violation of a protective order case simply because the alleged victim in the domestic violence situation calls and says, hey, sweetheart, I'm sorry. I know I kind of overreacted this. Come on back over to the house. Come stay with me. Or let's meet up somewhere. Let's hang out or whatever. Well, the temptation is to say, yes, let's reconcile. Let's get back together. I'm going to go back home because I don't want to be away. The problem is this. Police officers know who have a protective order. In fact, there's many times officers that are paying attention to whether or not someone goes back to a particular location that's prohibited under protective order, or more importantly, you are putting yourself at serious risk, even if they're not looking. You're putting yourself at risk if the next time there's any type of problem, or if a police officer just walks up and asks who you are, you could easily find yourself back in jail, now being charged with a Class A misdemeanor of violation of a protective order. So I'm not giving you specific legal advice here because I don't know your situation, but I am going to tell you this. Don't ever trust just because someone else wants you to come back to them in violation of protective order. Don't ever believe that you're protected just because the alleged victim asked for it. It doesn't work that way, okay? Now, let's talk about what should you do if a detective calls you about a possible violation of protective order. What if a detective finds out maybe you did have contact with somebody you weren't supposed to have contact with in violation of an order? What should you do? Well, if you have either been charged or maybe you're being asked to speak with an investigator about this, you need to make sure you have legal counsel by your side. I would advise that you need to be very careful what you say. Because listen, particularly if you are innocent, shouldn't you talk to the temptation is to say, and I get people tell me all this time, if I'm innocent, shouldn't I just talk to the detective and explain my situation? I'm sure he'll understand. Well, be careful. That is a very risky proposition. In theory, it would be great to think that you can tell your story and you're good to go. But in reality, what's going to happen is they're going to interrogate you, and every little thing that you say can be used against you, and that might be the basis for a probable cause warrant to arrest you for the crime of violation of a protective order. So, the moment you receive a phone call from a detective, you should find and contact an experienced and aggressive criminal defense attorney that can help walk you through your next steps, okay? Now, let's talk about violation of protective order laws in Texas. Under the Texas Penal Code, section 25.07, entitled Violation of Certain Court Orders or Conditions of Bond in Family Violence Cases, it states that a person commits an offense if in violation of a condition of bond set in a family violence case and related to the safety of the victim or the safety of the community. If this order is in place, so here's what it is. If the order is in place, you had to have acted intentionally or knowingly. You communicated directly with a protected individual or a member of the family or household in a threatening or harassing manner, or a threat through any person to a protected individual or a member of the family or household, or in any manner with the protected individual or a member of the family or household, except through the person's attorney. Now, notice what I'm just telling you here. Except if the contact is through the person's attorney or a person appointed by the court. So otherwise, if you're told not to have contact and you do it anyway, you could be in violation of the protective order. The second part of that is if you go anywhere near the following places as described as a condition of bond or in the protective order itself: the residence or place of employment or business of a protected individual or a member of the family or household, or any child care facility, residence, or school where a child protected by that order or condition of bond normally resides or attends. Finally, you can also be charged with a violation of protective order if you possess a firearm in violation of that order, or if you harm, threaten, or interfere with the care, custody, or control of here's a weird one, of a pet or an animal or an assistance animal that is possessed by a person protected by the order. Now, I've just given you a bunch of things there, okay? But the big ones are what? You can't contact someone you're not supposed to contact according to the order, and you can't go somewhere that the order says you're not supposed to go. It doesn't matter how much the other person on the order wants you to come. Okay, that's the clear thing we want to be aware of. Now, what is the penalty for violating a protective order in Texas? So a violation of protective order is a Class A misdemeanor for a first offense. That means it's punishable by up to 1 year in jail and up to a $4,000 fine. However, if they can prove that the state of Texas can prove beyond a reasonable doubt that you committed the crime of a violation of protective order and it was issued as a result of a victim being a victim of sexual abuse, sexual assault, indecency with a child, stalking, or indecent assault, it can be charged as a state jail felony, punishable by up to 2 years in prison and up to a $10,000 fine. Finally, there can be, if you've been previously convicted of a charge of a violation of protective order, or especially if you've had 2 or more times of a violation of protective order in a 12-month period, you could also be facing a third-degree felony, punishable by up to 10 years in prison and up to a $10,000 fine. Now, here's the question I get all the time. As soon as someone calls me, I'll get an alleged victim call my office and say, can I remove this protective order? Is there a way for me to modify or remove the protective order? It is definitely possible. The most common means by which to have a protective order removed is to retain an attorney, an experienced criminal defense attorney, to examine the evidence. If the alleged victim desires to have that protective order modified or removed in some way, then they can, at that point, there can be an affidavit that's completed. And without getting into any specifics about what that person may decide to say or not, the main thing that the court is going to be looking for is whether or not, number one, does the alleged victim desire or have a wish to have it removed or modified, and do they continue to show any type of fear or concern related to any contact between the alleged victim and the accused, okay? So that has to happen. I'm going to tell you, most judges are not just going to remove a protective order because you want them to. There has to be those affirmative steps taken. All right, finally, legal defenses. What are some of the legal defenses to a violation of protective order? One of those is a lack of notice of the protective order. What if you did not actually receive notice of the protective order going into effect? What if you moved residences or the paperwork was not served to you? If you never received a notice that the protective order ever existed to begin with, you cannot be held criminally liable for a violation of an order that you didn't know existed. Remember why. The state of Texas must prove that you did so intentionally or knowingly. In order to act intentionally or knowingly, you had to know about it, right? Okay, so that's defense number one. Number two, what about lack of criminal intent? So what if you had no idea that the alleged victim was at a particular location or when you arrived there? And we see this happen, we've had this happen many times, where we'll have a client that'll go somewhere and they have no idea the alleged victim's going to be there at all. And so, and I'll give you an example. What if you are at your residence, which is not listed under the protective order, but the alleged victim comes to your residence banging on your door wanting you to open the door, and then they call the police? Well, now technically you are there. It's going to look like you were there, but you didn't go to them. They came to you and you didn't open the door. They're going to have to be able to still prove that you had the criminal intent, that you acted intentionally or knowingly in order to place yourself within that proximity of the alleged victim, okay? For example, what if you visited a restaurant in the area and the alleged victim showed up while you were eating? We've actually had this happen multiple times. Obviously, you did not know that the alleged victim was going to be there and be present, or you probably wouldn't have gone there. But it is critical in a situation like this that you are able to establish and document your arrival. If maybe you had some witnesses that were with you there while you were eating, and that can be documented. All of that needs to be done because the contact must be intentional or knowing in order for it to be proven by the prosecutor, okay? Remember, you have no burden to prove anything. The state of Texas has to prove everything beyond a reasonable doubt. So it's critical that you work with an attorney as a partnership to work and make sure that that evidence is able to be exposed to hopefully be able to exonerate you, okay? Now, finally, if you are facing a felony protective order case and some of these defenses apply to you, you especially need to make sure that you get this evidence to your attorney early. So that way a grand jury can review this information, and because it's a felony, the grand jury could possibly lower the case to a lesser charge down to a misdemeanor or no bill the case, which means they could get rid of it altogether, okay? Now, listen, I've only given you just a little bit of information here, but I hope that it was helpful for you, okay? I want to thank you for joining the Fulgham Law Firm. I promised you, if you waited around to the end of this video, I'd give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. All you have to do is click the link down below. We'll send you over some pertinent information that will be of help to you. And listen, if your case is out of the North Texas, maybe you or a loved one is facing a case like this out of the North Texas area, don't hesitate to contact the Fulgham Law Firm at this phone number right above that you've seen above me on the screen. Call this number and we'll be happy to give you a free case analysis and a consultation. And I want to thank you for joining us here today. Subscribe to our channel, like this video. We'll send you more great content, okay? Thanks again.